Right, well, hello everyone, and welcome to this talk held by the Centre for Community, Gender and Social Justice. We're delighted to welcome you here in person and online for this talk. And just to give you a little bit of detail about the way the talk will run before introducing our speaker. So the talk is being recorded. Just the talk itself and the slides. So the question and answer session afterwards will not be recorded. The talk will go on for about 25 minutes to half an hour, and then there'll be an opportunity for people to ask questions. And so from those of you in the room, quite straightforward show of hands. Those of you online, if you'd like to put questions in the chat, and we'll also come to those as well. So I am delighted to welcome Nikita Sonavane from University of Oxford to talk to us today. So Nikita has worked as a legal researcher and advocate for 5 years. She is the co-founder of the Criminal Justice and Police Accountability Project, a Bhopal-based litigation and research intervention, which is focused on building accountability against criminalisation of oppressed caste communities by the police and the criminal justice system. Nikita has previously worked on issues of local governments, forest rights, and gender in Gujarat. She graduated with a BA in political science from St. Xavier's College in Mumbai, and she has also subsequently studied for an LLB in law and an LLM in law and development. She is currently a visiting research fellow at the University of Oxford, where she is working on anti-discrimination law in India. Her writings have been at the intersection of policing, caste, and digitization of the criminal justice system in India, and have been published by the AI Now Institute at NYU, Indian Express, the Hindu Caravan, amongst others. So I'm now delighted to hand over to Nikita, who will tell us a bit more about her work.
Thank you so much. Am I audible?
Yes, you are. Yeah.
Okay, great. Thank you so much for inviting me, and I'm sorry I couldn't be there in person, but nonetheless excited to be here and be in conversation with everyone. And thank you again for that introduction. So I just want to start by speaking about what is my entry point into the question of policing, right? Caroline has spoken about, my work on policing, particularly the criminalization of oppressed caste communities in India. So I want to speak about, that is what is my entry point into understanding the question of the criminal woman or policing in India. It is, of course, as a criminal defense lawyer, my work as a criminal defense lawyer and as a legal researcher, and particularly with the Criminal Justice and Police Accountability Project, where we are, amongst other things, focused on sort of unpacking what are known as the discretionary powers of the police and looking at sort of the sort of Brahminical genesis or the casteist origins of policing, and thinking about particularly its targeting of certain communities that I will speak about more, who are known as the denotified tribes or the Vimuktas, as they like to assert themselves, who are a group of nomadic, semi-nomadic tribes categorized as hereditary criminals or criminals by birth. So today's conversation and this discussion, I want to explore, the intersection of gender, caste, and violence in the construction of female criminality, particularly by focusing on its manifestations in current times, right? So that the sort of contemporary characterization of the criminal woman. And I want to do this, of course, the category of the criminal woman extends beyond the realm of caste. So, it's a largely a gendered category, but I want to speak about this and complicate that gendered category a little bit by focusing on the way in which the category of the criminal woman has been constructed in the context of the denotified tribes. And in doing so, I want to rely on the empirical research around policing that we've done at the CPA project, particularly on alcohol policing in India, or as we call it, excise policing in India. So to just briefly encapsulate, there are two things that I want to do. One is, like I said, to complicate the category of the criminal woman in India as being a casteist category, as a category that's rooted in the institution of caste. And I want to utilize this category of the criminal woman to sort of for us to think about the origins of policing, or the casteist underpinnings of policing, as which has largely been understood as a colonial institution, but to complicate the idea as a casteist colonial institution. And in speaking about the criminalization of women belonging to the denotified tribes or the DNT communities, I want to focus on this one particular denotified tribe, which is largely focused in central India, which is where my work is located. And these are the tribes known as the Kuchbandiya community, who have now, of course, post-independence been deemed as a community of habitual offenders. So before I start, for the uninitiated, I just want to sort of lay down brief context to the caste system. Arushi, can we go to the slide? Sorry, I've been missing out on this. Yes, following. The next slide, yeah. Perfect, yes. So a little bit about, the origin story of caste, right? So just a quick context that it's obviously a lot complicated institution, but a sort of brief encapsulation is that it's a graded system, a graded hierarchical system, four-tiered system known as the Varna system, where occupation is assigned by birth, and particularly interdining, marriage, all of it is determined by where you are placed in the caste hierarchy, right? So then there are the highest caste that are known as the Brahmins, who are considered to be, the priestly class, so priests or so-called intellectuals by birth. And then there are those who fall on the spectrum of the lower caste, or those that even fall outside of the caste system, popularly in now, of course, in a lot of global caste discourse known as the Dalits, who are formally categorized as untouchables, but also a lot of other oppressed caste communities, such as the denotified tribes, who are essentially ethnic communities that didn't ascribe to the caste system, largely followed a pattern of being clans, who fall outside of the caste system, so don't ascribe to the four-tier model of caste. And the sort of persecution, I want to speak about the kind of persecution that they face as a result of them falling outside of the caste system. So, but particularly in speaking about caste, what I want to talk about is the kind of differential treatment that women belonging to oppressed caste communities face, which is as a result of what a lot of theorists, anti-caste scholars have conceptualized as Brahminical patriarchy. So Brahminical patriarchy is something that ensures that the caste system can be reproduced without violating the hierarchical order of closed endogamous circles, in which, distinctly from the higher to the lower caste, it's ensured that, through a control over and regulation of women's sexuality, basically it is ensured that the caste system is maintained. So questions of making sure that there is no intercaste marriage, and people from higher caste and lower caste don't intermarry. This sort of maintaining the purity of the caste system, or what is called endogamy, is maintained through a control over women's sexuality by saying that we have to make sure that women are not marrying outside of the caste fold in order to ensure that the caste system is maintained. And a lot of scholars particularly have characterized, therefore, Brahminical patriarchy and its impact on women placed across the caste order as not just as graded patriarchy. So what I want to speak about is how within Brahminical patriarchy, women belonging to the lower caste communities, the so-called lower caste communities, are understood or are characterized as having less honor and dignity, and just the way in which their bodies come to be constructed in line with Brahminical patriarchal notions of honor, dignity, or the lack of it. So, I mean, it's just this broad context that I want to lay down, because a lot of these ideas will keep coming up as we think about, the category of the criminal woman. And I want to, so, before I dive into this, I want to speak about, next slide, please. I want to speak about, my work and how I came to be interested in this question, right, of thinking about criminal women and, how this category has come to be. So in 2018, this is in central India, particularly in the city called Bhopal, which is where I work, a woman belonging to a Pardhi community, which is a denotified tribe, died by suicide as a result of police harassment. And in India, to prosecute public officials like the police, we need sanction from the police department in order to be able to criminally prosecute police officials. And the police department, as is the usual course of things, denied permission for these officials to be prosecuted. They said, there is no criminal case that can be made out against them, which is why a collective of people belonging to denotified tribes approached the Madhya Pradesh High Court, which is the highest constitutional court in central India, to sort of say that, there's a case for abetment of suicide that can be made out. Something very interesting happened in this case is that the defendants in this case put forth an argument to say is that the woman who had died as a result of suicide, she had given a dying declaration saying that these three police officials that had harassed her and abetted her suicide. So the defense made an argument to say that this is a woman who belongs to a community. She's a habitual offender. She belongs to a community who are these repeat offenders, habitual offenders. And so what she said in her dying declaration is not believable. And so, I mean, this is an argument in any other court of law which probably wouldn't, because wouldn't have been accepted, but because largely it was not the woman, the victim whose whose veracity or whose character was mentioned here, but the court decided to delve into the criminal antecedents of the victim in this case, because she belongs to a community which is classified as habitual offenders. And then what the court did is delve into her criminal antecedents and discovered that all of the cases against her had either been pending in court or acquitted. And we saw this, we see this trend repeating constantly, right? So it is in 2019 also, there was another case that I worked on where 4 women belonging to the Pardhi community had been sexually assaulted. And they attempted to register a police complaint, or an FIR as we call it in India, against that sexual assault. But instead, an FIR for theft against them was registered by saying that, well, these are women that belong to these communities that are deemed as habitual offenders. So there are various strands that emerged from these 2 incidents that I've narrated, right? One is, of course, the category of the habitual offender, which is repeatedly utilized to not just, utilized to sort of overlook and obfuscate the harm caused to women belonging to DNT communities. Of course, there are these women belonging to the denotified tribes that are being understood as habitual offenders. And then there is the police, which is at the center of this construction of the habitual offender category, right? And all of this draws back to the fact that it is largely these people belonging to oppressed caste communities that are understood as habitual offenders. So what I want to do today is explore these different strands and reflect on how they all come together in the construction of the category of the criminal woman through the research that we've done in central India. But before that, I want to speak a little bit about the denotified tribes, right? This habitual offender category and the sort of genesis of that habitual offender category and the origin story of the denotified tribes, which lies in this law known as the Criminal Tribes Act. Can we move to the next slide?
Nikita, can you hear me?
Yeah, I can hear you.
Could you? Sorry, the sound in this room is really distorted. So if you were able just to speak a little bit more slowly, then I think we would find it easier to follow in the room. I apologise to interrupt.
Yeah, is this better?
Not really, no.
Okay, let me just figure.
Have a sense of anything we might fiddle with to help the sound. I can only make it louder, or I tried quieter and it didn't help. But if there is an obvious technical fix, but if any of you are sitting there thinking, oh, for goodness sake, why don't they just
No, having her up there so that we can see and read the lips a little bit helps a lot. And then if she just slows down a little bit, that will help a lot. But outside of that, just sound distortion makes it so much harder.
hard, isn't it? I'm really sorry.
I'm volunteer to go look for Matt if he's there.
If Matt is there, yeah, he might know how to stop the
I'm
distortion.
volunteer 11.
But
Somebody saying that make the audio in the room because it sounds perfect online.
The good news is
Yes,
that the
exactly.
people online hear fine.
Exactly, it's just us in the room. So thank you. Sorry to interrupt. Nikita, do carry
No
on.
worries. Arushi, can we just go on to the previous slide, please? Yes. So a little bit about the Criminal Tribes Act and the sort of origin story of the category of the denotified tribes, right? So the Criminal Tribes Act was a colonial legislation of 1871 which espoused group and hereditary criminality, particularly for over 300 communities that were primarily nomadic or semi-nomadic tribes. Like I mentioned earlier, largely ethnic communities that ascribe to this clan model of functioning and, didn't ascribe to the caste system. And the logic of this was, these are communities, of course, the sort of stated logic was that they're born criminals and hereditary criminals. But if we delved into that further, we saw that, these were communities who in so many ways in the occupations that they practiced a wide range of, they were entertainers, some of them, made alcohol for a living, traditionally brewing alcohol. So various kinds of occupations that would, in contemporary terms, one would understand as that being the informal economy. So that was a way in which the logic of saying that, we need to be able to tap into this, right? And therefore we need to be able to discipline these communities. And also the fact that they didn't ascribe to the caste system was another sort of rationale. So we're seeing this combination of, economic control and, disciplining these communities to ascribe to the hierarchy of the caste system that is being laid out and that is culminating into the creation of the Criminal Tribes Act, right? So it is a form of social ordering that comes into place, and this entire logic of caste also plays out in the way in which, like I mentioned earlier, occupation is assigned by birth within the institution of caste, right? So the British were very easily able to tap into that logic to say, well, these are communities that are criminals by birth, so occupationally criminals by birth, right? So you see this caste, the logic of caste being tapped into the logic of coloniality, leading to the creation of the Criminal Tribes Act. And as a result of this, these were communities that were forced into sedentarization, to say that, their nomadic way of life is a threat. So they were put into reformatory settlements, and, they would try to be disciplined, they try to discipline them through manual labor, so on and so forth. And on release, they were required to, every movement was heavily surveilled, and, their fingerprints, etc., were being taken by, initially it was through bodies or like the village headmen, because this is largely happening in a rural setting. So through different kinds of agencies in the village. But then what we also see is that in so many ways, the police comes into being, right? So the police is then gradually by 1911, 1871 is when the law comes into being. By 1911, it is applied all over India, and then the police becomes responsible for disciplining of the criminal tribes, right? So they are maintaining what they call these registers, which document the criminal antecedents of these communities. So things like fingerprints are taken, movements of the so-called criminal tribes are being recorded. So in so many ways, we're seeing that what the Criminal Tribes Act is doing is granting arbitrary powers to the police to say that you don't have to. There is, because the sort of presumption of innocence doesn't exist in this law, right? So the police doesn't have to in any way investigate a crime against anybody. They just have a sort of free rein to classify some people as criminals. And I think what I want to do here is sort of make a brief segue into the police in India and speak about the sort of origin story of the police in India, which is in so many ways coterminous with the existence of the Criminal Tribes Act as it's playing out, right? So the police in India was introduced, in the early 1840s, and it was modeled after the Irish paramilitary police, and the sort of stated rationale was that we need the police to respond to two problems of the colonial government, right? One is, of course, to say that we need to evolve a sort of model of policing, which is like going, veering away from the pre-colonial model of the village watchman as it existed in India, and at the same time to say that we want to be able to make sure that because in 1857 there was this first revolt against the British government. So we need to make sure that soldiers are freed away from policing responsibilities. And so we have a dedicated institution that is now functioning and carrying out policing responsibilities, right? So, Radha Kumar, who's a historian in India and, works on policing in the Madras region of South India, she says that when she speaks about the way that the police function, she says that my point here is not that the police always reaffirmed caste hierarchies, although they often did, but that caste politics and policing were not independent of each other. So when we see the way in which the police is exercising its discretionary powers, or the category of the discretionary powers of the police are constructed, we're seeing that it is informed by these hierarchies of caste, right? So like using the sort of knowledge practices that were used to identify colonial subjects, based on their caste identity and occupation. So it was like the respectable priest, which is the highest caste, the warriors, the merchant caste, and of course, then the wandering tribes, such as, the denotified tribes who were involved in various kinds of occupations. What the colonial police did was to channelize the resources at their disposal to effectively police the broader rural population according to these lines, right? And which is why, like, the police were not merely and largely, even now when we think about policing, or there are discussions that happen in India around policing, a lot of it is characterized, or, the original point of it to say, oh yes, there are problems with the police because the problems with the police exist because it's a colonial institution, and they're colonial, they were colonial agents, and you see that logic being carried out to contemporary India. But what this shows us is that they were not merely colonial agents, but this was an institution that was designed to tap into the logic of caste, right? And coloniality itself and colonial criminality itself tapped into that sort of logic. And we're seeing the police and the institution of policing embodying that, right? And it's important to talk about the role of the police because it's one that is crucial to shaping the archetype of the criminal woman, and in so many ways breathing life into the Criminal Tribes Act, and of course, the subsequent categories, administrative categories that emerged from the Criminal Tribes Act, right? Yes, next slide, please. So I want to speak a little bit about, what happens after 1871. This law is repealed, it's amended thrice. And then, of course, the Indian independence movement has begun, and the Constituent Assembly has been set up in India to, formulate the Indian Constitution. And then what are the kind of conversations that are happening in the Constituent Assembly around the Criminal Tribes Act, right? And so there's a lot of push in the Constituent Assembly to say that, we need to get, this law needs to be retained because these are communities that are criminals, they are independent India. And so this politician known as Khandekar, who belongs to the then untouchable community, who says that that we need to get rid of this law. But then, of course, he's opposed by another constituent assembly member. Things be imposed on the movement of the criminal tribe people when they're a source of danger to other law-abiding citizens. Could anyone be serious in saying that restrictions and conditions imposed on the criminal tribe should not have been imposed at all? So there is this sort of discord within the Constituent Assembly, where on the one hand, this idea of the criminal tribe is not fitting in with the idea of the independent Indian nation, but at the same time, they're convinced by the fact that these are communities that are hereditary criminals and therefore want to retain the law as well, right? So Nehru, who's the first prime minister and who was at the time a vocal advocate of the repeal of the Criminal Tribes Act, writes to the chief minister and says, chief ministers of various states, and says that, we need to repeal this law, but at the same time, while saying that, while advocating for the repeal of the Criminal Tribes Act, he says that if left to themselves suddenly, these communities might drift into wrong courses, and therefore that rehabilitation should be carried out, and we have to deal with this problem of the criminal tribes in a different way by evolving questions of law and order. So we're seeing, of course, that even those who are pushing for the repeal of this law are buying into this whole logic of saying that in some version this law must be retained, right? So we have the 5-year plans after independence that are set up, the first 5-year plan, which is basically required to sort of evolve, welfare schemes for independent India, and what the committee is set up, and it's a Criminal Tribes Act Inquiry Committee is subsequently set up in 1949-1950, which makes a case for the repeal of the Criminal Tribes Act by saying that it is inconsistent with the principles of equality and freedom that were championed as the foundations of independent India. So finally, in August of 1952, the Criminal Tribes Act is repealed, and it's repealed with the condition that will be a separate sort of system evolved to address the problems of the criminal communities. And that is how we see the category of the habitual offenders coming into play, right? So the habitual offenders narrative that the court in central India relies on, in the case I was referring to earlier, we see this category coming into place in 1952, almost immediately as soon as the Criminal Tribes Act is repealed. This category is very interesting because it doesn't say explicitly that certain communities are criminals by birth. Instead, it's a sort of nebulous category which says that, well, there are certain people that are habitual offenders and we need to deal with them. And of course, at the forefront of dealing with the category of habitual offenders is the police. So as a result of this, what we see happening is that the criminal tribes registers now become habitual offenders registers, where all of these details continue to be maintained, and also different terms begin to be evolved, right? So we're seeing like different sort of terms such as history sheeters, rowdy sheeters, being used to not just describe the habitual offenders in different parts of the country, but also registers, the sort of criminal registers that store this information about these habitual offenders, right? And I want to speak a little bit about how, as we see it in practice, as defense lawyers who are representing the so-called habitual offenders. Of course, in addition to extensive surveillance, what we're also seeing is that the determination of a habitual offender is not contingent upon conviction, right? Conviction by a criminal court. So anybody can be deemed habitual offender. In fact, what we're even seeing is that even if a person has been acquitted of an offense by a criminal court, they can still be deemed as a habitual offender. So what we're seeing is that policing powers of habitual offenders are in so many ways operating outside of the logic or the rules and procedures of the formal criminal legal system, right? So we're seeing that the sort of rationale is also changing in the way that, earlier within the criminal tribes that you're saying that there are certain communities that are criminals by birth, but now the narratives of criminality are replaced with narratives of economic deprivation, addiction to psychotropic or narcotic substances, indiscipline, so on and so forth, saying these people are dangerous. And we're also seeing, therefore, then that the narrative of caste changes, right? So people that are considered that are economically deprived, people that are seen being addicted to narcotic substances, are all people that largely belong to oppressed caste communities, and economic status, so on and so forth, is intimately tied to one's caste location. So we're seeing that the rationale of policing is informed by the rationale of caste, although the sort of narrative now is a more sort of economic and other kinds of casteless narratives, which is of course also nestled within this more palatable administrative category of habitual offenders. And I want to focus on how this is manifesting within alcohol policing in India. Can we move to the next slide, please?
So Nikita, we've got 5 minutes more.
Yes, following. I think I've missed a lot of slides. Not the best idea to be making slides. Yes, following slide. Yeah, we move on. I will tell you where to stop, Arushi. Yes, this is where. So the reason we were interested in looking at alcohol policing in India is because 1/6 of almost all arrests that are made in India are made for alcohol policing. And we wanted to see, and in our experience as lawyers, we see that it's a law that's very commonly used by the police on a daily basis, and also very interestingly, of all of largely the kind of people that are implicated for offences in India or accused persons largely belong to the category of men, right? I mean, in India, gender is only recorded in binary terms. So those who are characterized by men are largely the ones that are accused for various offences. But what we saw in central India is that not only are women charge sheeted for offences, but the women charge sheeted for excise offences, as the alcohol law is called in India, is higher than the national average for which women are charge sheeted. So, which is why we wanted to see how is it that this law, where the principle of charging predominantly charging men for offences is overturned. We wanted to see how is it that women are being criminalized under this law, right? Next slide, please. So to do this, we studied 540 FIRs or police complaints that were registered under the Madhya Pradesh Excise Act of 1915 between the years of 2018 and 2020. What we saw was that first we found that, of course, largely the communities that were implicated were those that belong to the denotified tribes or the scheduled caste, which is the Dalits or other indigenous communities known as the Adivasis that were implicated for alcohol police related offences. And secondly, that the percentage of women implicated in our survey of 540 FIRs was 8%, which, like I said, is higher than the average percentage of women charged across the country. So it's 5% for India, but it's 8% for excise policing only in Madhya Pradesh. Notably, can we move to the next slide, please? Yeah. So notably, all but 2 of the 41 women that were implicated belong to the Kuchbandiya community, which is a denotified tribe, the Kanjar community, also a denotified tribe, and the Gond community, which is an indigenous community, not a denotified tribe, but an indigenous community in India. So it's while it suggests that, there are few women who become objects of policing in India, fewer than men, but particularly within that, only women belonging to a few communities are disproportionately represented within the system, right? And I want us to the next slide. I want to focus very importantly on this one police station that is emerging within our data set, right? And we're seeing that this is the Ghamapur police station, where we're seeing that 25 of the 41 women that were accused of excise policing in this one station belong to the Kuchbandiya community, and 33 of the 34 women were both Kuchbandiya and Kanjar. So we're seeing that this finding is also corroborated by the analysis of all persons that this particular police station charged, right? So of the 1,094 excise related offences that this police station charged people for, 624 of them. So nearly 7% of those belong to the Kuchbandia communities, and 2 of every 3 Kuchbandia person arrested was a woman. So we are seeing that between 2018 to 2020, over 508 women are arrested by this one police station alone. And you may ask, and the sort of broader rationale in India, if you ask anybody about why alcohol policing needs to be carried out, they will say, oh yes, we need to control the illicit liquor mafia, and we need to make sure that people are not dying as a result of consumption of spurious liquor. So when we delved very closely into what kinds of offences these women were being charged for, we saw that it was actually for the sale of small quantities of liquor, particularly that which is known as mahua. It's a traditional liquor that people from these communities make, and really small quantities. In the maximum 80% of the FIRs were registered for in cases of mahua for about a maximum of 5 liters. So what we are seeing is that while the popular narrative is that we want to go after the liquor mafia, we're actually seeing that in terms of everyday policing, it's these women belonging to these criminalized tribes being charged for making small quantities of alcohol, which is also small quantities of indigenous liquor, which is a significant part of the history and culture of these communities, right? So they make mahua when somebody is born, it's made on funerals, so on and so forth. So what we also did is, can we move on to the next slide? Yeah, next. Yeah, next. This shows you sort of like the whole picture of, how 80% of the FIRs are for such ridiculously small quantities. Next. Yeah. So what we wanted to see is, how does this play out, right? When this category of the habitual offender is adjudicated in court. So and before that, I just want to add that on an individual basis, if you look at individual women belonging to Kuchbandia communities, we saw that there are individual women who are charged with at least 23 to 28 cases of alcohol policing. So 23 to 28 times being termed as being offenders of violating the alcohol law in India, right? So we're seeing, that these are cases, how these cases are being adjudicated when they're going to court, right? So we did a survey of bail orders from the High Court of Madhya Pradesh, which, like I said, is the highest constitutional court, between 2018 and 2020, and saw how the court is adjudicating questions of liberty of women belonging to these communities when they come to court to file for bail. And we saw that in 2 of the 3 cases, bail was denied simply. So the bail order simply says that these are women who are habitual offenders and therefore bail cannot be granted. So when questions of bail are being heard by court, there are certain thresholds laid down by criminal law. And one of the most primary thresholds is for the court to make out a case to say whether prima facie there is an offense that is made out or not. But here we are saying that the category of the habitual offender becomes like an all-encompassing descriptor for the court to say, well, she's a habitual offender, so we can grant bail, and no other reasons need to be provided for that, right? In one case for anticipatory bail, the state merely claimed that 50 cases have been filed against the applicant woman in this case, and the judge didn't even delve into whether those cases were pending, what was the status of those cases, and merely said, oh well, 50 cases, which means this woman is a habitual offender, and therefore refused her bail. In fact, what we've also seen is that when this category of the habitual offender is adjudicated in court, even when bail is granted, harsher bail conditions are imposed. So in one of the cases, a woman who had spent 193 days being in judicial custody was granted bail after imposing harsher bail conditions on her, right?
Nikita,
I'm just going to need 2 minutes to wrap up.
Yeah, because we would love to have an opportunity to ask questions too. Thank you.
So when we spoke to women belonging to these communities, we largely saw that there were these common narratives that were emerged, right? Like each time the police would come to pick them up, they would say, you're running this liquor mafia, you're at the head of this liquor mafia. So largely, can we move on to the next slide? Yeah, so if you see this here, we're seeing that, women saying policemen enter our home anytime in the night and we're subjected to violence. So what what we're seeing also, and this quote by Ambedkar, who is one of the foremost figures in the Indian Constitution, saying that, women are actually the sort of linchpin of this criminal mafia, right? So even though they're not involved in the actual raids, they're the ones who are driving this forth. And I want to speak about, next slide, I want to speak about very quickly before we delve into the discussion about how this narrative of the criminal woman differs. So in 1870, the Infanticide Act came to be, which is the sort of first legal point of thinking about the category of the criminal woman. And it's mainly women belonging to upper caste communities that were considered to be in violation of the Infanticide Act, and are seeing that notions of shame, honor, etc. are imbued to these women for violating the principle of motherhood, which is considered to be essential being a woman. But on the other hand, when we see the sort of narrative of the criminal woman as it is, applied to women from oppressed caste communities, we see a very sort of distinct narrative being played out, as the quote that is up on the slide shows, that it's understood that, these are women that have no honor, right? So it is understood that they're loose character, implying that, they have illicit sexual relations, so on and so forth. So the notion of deviance and criminality in India, in the way in which the category of the criminal woman is constructed is enmeshed within the institution of caste, right? And in India, the origin story of not just the category of the criminal woman, but also how custodial violence is understood, is largely derived from this one case of Mathura, where a woman belonging to an Adivasi community was raped in police custody. But we have seen that these narratives of understanding policing, of understanding violence against women in police custody are largely determined by a sort of abstract understanding of coloniality, completely devoid of caste. But it is important that, in thinking about the category of the habitual offender, in thinking about the category of the habitual offender criminal woman, we're rooting it within the institution of caste, and also then thinking about the institution of policing, which is in so many ways responsible for bringing life into this category, and thinking about what is it that it says about policing. Just the last slide and I'm done. Yeah. So I want to close with these questions of thinking about, what does the category of the habitual offender, denotified tribal woman reveal about policing in India, and how do we understand the logics of policing in India in light of the casteist criminalization of these women? And these are the kind of questions that I hope we can discuss during today's conversation in the Q&A. And I'm sorry for overshooting time.
Not at all. Thank you so much. That was fascinating. And